Welcome to this presentation of the Rotary Club of North Bethesda, Maryland, USA. Our club was established in 1974. We meet every Friday morning at 7:45 a.m., and we often invite guest speakers to give presentations on all kinds of interesting subjects. Please contact us through our website at nbrotary.org. And thanks for watching. Our speaker today is Minh Lee. He's a director at FINRA, the Financial Industry Regulatory Authority. Minh serves in FINRA's Corporate Financing Department with over 25 years of experience in the regulation of public and private offerings. Currently, Mr. Lee manages the department's Private Placement Review Program, which conducts regulatory oversight of broker-dealer participation in retail private offerings. In addition to overseeing the review and investigation program, Minh's duties include developing policy and providing guidance on corporate financing, investment banking, and other capital-raising related issues. He's also responsible for providing subject matter expertise to FINRA's examination and enforcement staffs, and on occasion provides testimony for hearings and regulatory proceedings. For the past 20 years, he's been a member of FINRA's Sales Rep and DPP REIT qualification committees, which are responsible for developing test questions for brokerage licenses. Prior to his current functions, Minh managed the department's Public Offerings Review Program, which is responsible for regulating underwriting terms and arrangements in public offerings, and he graduated from the University of Maryland. He attended the Wharton Institute of Executive Education and is a certified regulatory and compliance professional. Minh?
Thank you for the intro, Kevin, and certainly appreciate the invitation. I think some of you might be familiar with FINRA, some of you may not be. So I'm glad to give you an overview of what we do, especially because, in addition to the regulatory work we conduct, we've really made it a focus to concentrate on investor education, but not only to educate the public, but also to bring awareness that we provide a lot of services and a lot of resources for investors, especially as the investing public grows with the different means to participate in the securities market. So this is a really great, another great opportunity for us to get out there and talk to folks like yourselves. I have a slide deck here, and I have to admit that I do a number of presentations throughout the year. It's usually very technical and legal in nature, so and it's on capital formation, the markets, and so forth. So I normally don't do a slide deck, so but in this case, because I'm doing an overview of our organization, I'm going to use it. So pardon, the way that we walk through. But I do want to offer that if you want to interrupt me or just ask a question, that's perfectly fine. I'm much more comfortable in the discussion format than just necessarily presenting to you. So with that said, let me just give you a little bit of background about myself, because it kind of, at least for me, ties in the history of FINRA a little bit, because we've changed as an organization quite a bit in the last number of years. So I came out of the University of Maryland with a degree in architecture and design, believe it or not. So I was interning, I was interning at Omni, and I'm not sure if you're familiar with the area, but Omni was a construction company under the Smith Corporation. So everybody knows about Smith. They build everything in this area, right? So the project manager was wrapping up this particular project, and they said, just find some work. We're going to bring you back onto the next project we have. So this is the 90s. You got to work. You can't live off your parents. So I found a temporary job at what was then NASD, which was the National Association of Securities Dealers at the time, and I just got an administrative job there. I was relatively fresh out of college and so forth, and it was always interesting describing what NASD was back then. Nick might be familiar with this, but back then, if someone asked me what I did, I would have to describe NASD, but then follow up by saying we own NASDAQ. And that was how people kind of connected what the organization was. So that back then, I didn't think I would end up having a 25-year career at this organization. It wasn't where I focused on my studies. Much like Victoria said, sometimes you don't start out where you end up becoming. So, but one of the things that I found really interesting was just the rules and the policies associated with the governance of this particular segment of the securities market, in particular the broker-dealer activities and conduct. So one of my jobs was to answer phone calls from lawyers who were trying to reach our analysts when they were trying to get work done. And a lot of our analysts at the time were dodging these calls. They were difficult, challenging calls. So they would just tell me to put the calls into voicemail. And eventually I became this, in between that was really annoying. So I just started reading the rules, and where I could answer questions for the lawyers who were representing the brokerage firms. And this got out, and next thing you know, the director of the department called me into the office. I thought I was in trouble before doing what I was doing, but they offered me a position as an analyst because I guess they recognized that I understood what they were doing. So again, back then we were a paper-intensive organization. We did a lot of eyes-on reviews. Like a lot of organizations, we've had to really transform ourselves through the years. We've relied much more on technology, risk assessment methodologies for how we do our work, as opposed to putting a 300-page document and reading all through it, which is probably why some of the analysts back then were fielding their phone calls. Right? But just so that history for me is a little foretelling about where FINRA is as an organization today. We're a much different organization. We've had some significant changes through the years. We've had some structural changes. In the about 15 years ago, we merged with the New York Stock Exchange, the regulatory side of the New York Stock Exchange, and that's when we became FINRA. We had to sell off NASDAQ and Amex and other assets that presented conflicts of interest. So we effectively became a much more focused regulatory body. So with that, let me just launch into the presentation. And if you don't mind, I'm going to share real quick. Like I said, I can stop to field questions and so forth. Can you all see my screen? It should be blank right now.
Yes.
Okay, great.
Yes, we can. Yep.
All right, so who we are. So I mentioned that we are a self-regulatory organization, an SRO, and our mission has been the same for 2 decades, which is protecting investors and the marketplace. We protected the investors by focusing on one target demographic of securities professionals, which are broker-dealers. You can have other channels and participants as advisors, other intermediaries, and so forth, but we are focused primarily on the broker-dealers. We are actually, in some ways, working for that particular industry because the reputation of the industry is important to the health of the markets and their role in the market. So while we regulate broker-dealers, we really are working for them. And that's where I'm going to explain how we've gone from an organization that has focused on citing rule violations and being punitive in nature to one that really promotes compliance on a principle basis. Like I said, we're not the government, but we work with the SEC and other authorities, regulatory authorities throughout the country. The SEC does have oversight on us. They conduct examinations of our program and all of our work. And as a policymaker myself, we have to deal with them quite a bit because many of our rules or activities have to be approved by the SEC staff. what we do. So just in line with the general goal of protecting investors in the market, we deter misconduct, right? So you deter misconduct by the threat of enforcement of rules. But you can also deter in other ways, one of which is to maintain oversight of a firm's supervision or procedures, or maintain contact and awareness of a firm's conduct. And in some ways, we bring technology in focusing on problematic individuals or activities. So the membership is aware of this. They know what we focus on from a risk assessment standpoint. So that in itself, without having to bring sanctions or bars, is a means for deterrence. Certainly, that alone doesn't work. I don't know if any of you are familiar with the FSA in the UK. They are primarily, their regulatory methodologies is primarily principles-based. In the United States, the regulatory work will, I don't think, shift that far. While we're shifting towards the middle, principle-based will always be somewhat in the enforcement world. That seems to be a method that resonates with some industry participants. So we have to detect, and we have a robust examination and surveillance program where we work with our membership and our broker-dealers and focus on areas of risk or high impact. And you know, we have to put the firms through a series of different normal tests and so forth, just to make sure that we're able to detect problems and address them accordingly. And lastly, like I said, we do have an enforcement staff that focuses on wrongdoing and misconduct. In some cases, there are many different degrees of misconduct, some more informal or requiring more informal action, others are more serious in nature. So we try to really take an approach of levying actions or taking actions that are commensurate with the nature of the harm. And without a doubt, the impact or harm on investors has become really the benchmark for how we do our work in that area. Quick overview on the industry. So when I started, and a few years after that, we probably had over 5,000 broker-dealers, well over 5,000 broker-dealers, a similar number of registered reps. That consolidated quite a bit over the years. It was probably down to 3,000, maybe a little bit less, and it's rebounded or stabilized quite a bit recently. So the health of the brokerage community, it appears to be stabilizing quite a bit. And the number of registered reps continues to be about the same. So we're, you know, probably feeling better about the industry than where we were, I don't know, 5, 6, 7 years ago. Like I said, our primary purpose is to establish rules that we administer and enforce, but we also administer rules that are applied by the federal securities laws through the SEC and so forth, and through municipal securities or the MSRB rules as well when it pertains to broker-dealers. As an organization, we've grown a little bit, but you know, that's been tempered somewhat by the use of and application of technology. We're really relying on tools such as, you know, hate to say some of these catchwords, but artificial intelligence, machine learning, really technology to help us do work in an efficient, streamlined way and a more effective way. So to some degree, where we used to have a lot of administrative staff, now we're mostly professionals with you know, analytical or legal backgrounds. My staff alone probably is well over 50% lawyers or MBAs. We definitely bring a lot of experience from the commission, some from the securities industry professionals, a lot of lawyers, especially with the tough labor market recently. We've been hiring lawyers straight out of law school and bringing them up from a training standpoint. We're obviously located throughout the country where there are financial hubs and population concentrations where investors reside. Naturally, we have a greater presence here in DC and in New York, but we do hold significant offices throughout the country. Now, I mentioned our examination program. In the past, we used to regionalize our workers to where the brokerage firms were located. And that was because we did a lot of on-site examinations, and our interactions sometimes required in-person meetings. But like the rest of the world, we've gone to a more virtual-based interaction, and our staffs aren't necessarily needed to be in the same location or same region as their, the firms that they are responsible for. So, for instance, you could have an analyst responsible for a firm in Denver be located in San Francisco or Dallas. So that regionality is really not that important anymore, and that's really reshaped the way that FINRA's organization is constructed these days. Just by way of background, as far as what types of departments or work that we do in FINRA, I'm in the Corporate Financing Regulation Department. We're under what is called the Office of the Chief Legal Officer. He's responsible for a lot of the policy making and the General Counsel's office, and there's some other operational departments there. But under him is also dispute resolution, which handles arbitration claims between investors and brokers. I'll get to that in a few minutes. We also have the Office of the Hearing Officers, which is responsible for reviewing appeals by broker-dealers who were subject to our actions, and also a few other legal-oriented departments. I mentioned we have an enforcement department. We also have a member supervision department, which is primarily responsible for the risk assessment, surveillance, and examination of brokers. We have a market regulation department, which is highly technical driven, because they have to monitor the millions and millions of trades on a daily basis. And they're also located in Rockville. So these are just some of the departments, but as a means of representing the type of work that we perform on a regular basis. Just quickly working through this, because I know that we don't have obviously too much time, but we examine firms for compliance with the rules and so forth. And like I said, we used to take a much more punitive approach. But I think in today's environment, what we try to do is serve as advisors and provide guidance to firms when it's the best possible outcome. And so enforcing the rules are important and so forth, but there's really a benefit to working with firms, making sure that their compliance systems are in place, and where there seems to be deficiencies, we address them more on a nimble basis, because as an outfit, my group, we investigate, produce referrals to our enforcement team and the SEC. It's a very laborious process. A case might take 2 to 3 years from start to sanctioning and so forth. So we always feel that we have to take a pragmatic approach at times to see if there's a better way to produce an desired outcome, as opposed to just punishing professionals. As I mentioned, we do have the power to subpoena registered representatives or firms, and of course, when there are findings, suspend and bar them from the industry. Because we don't have 2021 complete numbers yet, I'll just reflect what took place in 2020. And again, we're looking at 600,000 reps. The high majority of the reps in brokerage firms are very compliant. They spend a lot of money in producing procedures that induces compliance with the rules, where they can protect their investors and themselves as organizations. But when you have a demographic that large, you are going to find problems at times. So these are where we have focused in the past year An interesting figure there, again, is that $57 million in fines. And, this is public information, but it wasn't that long ago where we had sanctions of nearly 200 million. And that's really indicative of the shift that we've taken as far as trying to address problems in a different way. And just to let you know, when we were sanctioning firms in such a high volume back then, those monies did not go to our staffing or our compensation because of the, certainly the appearance of a conflict of interest. So it actually went to our technology development, where we were able to employ systems and tools to help us perform our work. But again, we've shifted the way that we finalize actions against firms, and we brought the fines down and instead tried to work with firms to make investors whole and through restitution and so forth.
We have a question right there at that point.
Sure, definitely.
You mentioned suspended 375 brokers.
Mm-hmm.
What's the total number of brokers? Is that 2% or 1% or 20%?
That's really tiny because technically there are over 600,000 registered representatives.
Wow.
So that figure is quite low. It's well under a fraction of a percent.
Yeah, that's good to know.
Yeah, that's
Thanks.
good to know. And there are ways that we hopefully, if you're active in the investment world, the sanctions, the suspensions, the bars are well documented, and I'll mention how investors are able to source that type of information. And of course, we don't act in or conduct our business in a vacuum. We work with other authorities such as the SEC. We refer matters that are outside of our jurisdiction. So bear in mind, when there's a fraud situation, we have to deal with the broker-dealer, but if there's a company, that is conducting or performing their business in a fraudulent manner, then that's the domain of the SEC, or perhaps the states in which they are domiciled, and in some cases the DOJ or the FBI. So we do work with criminal justice authorities as well.
I have a question.
Sure.
You have any new information as to how somebody like Bernie Madoff got away with what he got away with for so long?
We could go into a heavy conversation about that, and some of you might be aware of the intricacies. But so the professionals that we conduct oversight on are strictly broker-dealers. There is an industry of advisors that are largely operating under the fiduciary standards. And the SEC will conduct oversight on some of these advisors, but it's not the most robust process, if you will. So with someone like Bernie, and others might be familiar with the stories, well, he was both a broker-dealer and an advisor. And that interplay was probably used by him to limit the amount of scrutiny that his business was performing. And this is just my impression of what I know and so forth, but I think that he was smart enough to use that fact. And
So what safeguard do they have to prevent something like that from happening again?
Certainly from, Madoff wasn't the only advisor / broker-dealer. There are a lot of registered reps who are also duly registered as an advisor. And I think that scrutiny, realizing and recognizing that the reach from one authority to another can't stop with the impression that the other side is performing the work. So knock on wood, we haven't had the same types of issues. I think there was a Texas outfit, Stanford, that had a similar situation. But for the past number of years, I think the ability to use technology, a different method, especially in those types of situations, has produced results where we haven't seen the same type of problems.
Can I ask two questions?
Mhm.
The first one is enforcing the rules. Do you enforce only the rules within the country here or abroad? Because there's a lot of market frauds happens, in day-to-day business in the international ones.
Yeah, that's a great question, and we strictly regulate U.S. broker dealers and U.S. securities markets. Transactions overseas performed by securities professionals overseas are not within our jurisdiction. So, and quite frankly, once you get to transactions overseas, each nation, each sovereign entity has their own set of rules and standards. So it gets to be really tricky business. Where we focus is when there are affiliations between our broker dealers and those overseas, and how they conduct their business and transactions that might move from one to the other. An example.
Yeah, the reason I asked that question, my next door neighbor worked for SEC and then now in the private law firm, and he travels around the world, is basically investigating those kind of international market frauds,
Yeah.
Okay, the second question, when the broker tells you to buy something and no cost, and my question probably is very simple, do they get some kind of a kickbacks from the companies which they try to sell you, very highly recommend, saying this is the best investment you can make? Do they get any kickbacks from? Because there's absolutely no fees, but at the same time, I said, why a broker is pushing certain things,
Right. That's a very important question, and it is central to a lot of what we do. So what you're describing is a recommendation, and any conflicts that come with that. So in a lot of cases, those recommendations come with some form of compensation for the rep or the brokerage firm, whether in the form of commission or a discount if it happens to be a bought deal. There's a new regulation called Regulation Best Interests. And when there is a conflict of that nature associated with a recommendation that a registered representative makes to investor, that has to be disclosed. So, in effect, a registered representative can't introduce or recommend a security to you without looking at the nature of the investment and making sure that it's for the investor's best interest and not his or her. So that's a new SEC regulation called Regulation Best Interest. FINRA has always had a rule called the suitability rule, where before you make a recommendation for purchase to an investor, you have to make sure you understand all of the aspects of that recommendation, that security, and then on top of that, make sure that the investment is suitable. So meaning that it meets the investment objectives of the customer and not necessarily the objectives of earning compensation.
Yeah, but the average investor has no clue whether that particular broker has any direct or indirect financial interest in selling that security to you. So how does somebody finds out that,
There are rules when there are conflicts of that nature for that registered representative to disclose that to the investor.
Okay, thank you.
Sure. And Kevin and Nick, just let me know if you're running short on time and I can kind of speed through some of these. I mentioned real quick the regulation of markets and how active we are in monitoring the markets. It's a important area, certainly, especially during the pandemic, where trading is quite taking place at quite the premium or uptick than we've seen in the past. And then, like I mentioned before, the education that we provide to investors is paramount to the confidence of the market. And in addition to taking actions, ensuring firm conduct is within the scope and requirements of the rules. Protecting investors also involves some participation or understanding from investors, and the investing pool is getting larger. More people obviously are getting involved in investing. So that education, like I said, is paramount. I mentioned a little earlier where if you're engaged to potentially work with a broker, there's a tool called Broker Check to understand that broker's history and background. We have other resources. If you Google just FINRA hotline, there is a web page that really goes into detail about resources for prospective or current investors. It includes a helpline for seniors, something that we implemented a number of years ago. And it's a very effective program. We are able to help certain investors that might not have the access or the acumen to understand some of the complexities or particular situations that are being presented by brokers. There's an opportunity on that page for you to levy a complaint against a registered rep if there's a problem. There's also, if you come across an issue where it might induce a regulatory tip, and quite frankly, maybe you've dealt with a FINRA staff or something that is administered by FINRA. We have an ombudsman contact there. So it's a pretty useful resource as an investor, in my view, just to at least give you a sense of what's available in resolving any particular situation you have.
And I had a question.
Sure.
Is FINRA involved in any kind of regulation of cryptocurrency or anything like that? Are they looking at it?
Without a doubt. So, and it's a little bit of a tricky situation, one of which is whether certain types of ICOs or, cryptocurrencies are securities to begin with. But the other side of it is that broker-dealers are involved. They are selling investment funds that are in the business of the crypto world. Broker-dealers, by and large, are not selling the currencies directly. Sometimes they sell a form of it called tokens. But it's it's definitely something that is fluid. Obviously, all the regulators are paying attention to what's going on there. And from our standpoint, we're naturally paying attention to how the broker-dealers are administering any investments that are associated with that space. So yeah, without a doubt, there's a lot of attention.
I mean, if FINRA is tracking 87 billion transactions, how are they going to keep track of crypto transactions?
Well, I think that's part of the allure of cryptocurrencies is that blockchain, that decentralized transaction record keeping is somewhat designed to present a different scenario. So, for us, what we care about is when broker-dealers are engaged in transactions that might use cryptocurrencies as a form of payment. That's a very complicated situation for us because if you're involved in that space, it requires an understanding of how wallets are used. And I won't get into it, but that's basically a means of the payment between either goods or assets or interest and naturally the currency. So when broker-dealers are involved in that type of processing, if you will, then it obviously matters to us. So that's a very complex situation that we're monitoring.
And we only have a couple of minutes left, Minh.
Okay, so real quick, I think this is an important aspect is, and if you're not familiar with it, we do administer an arbitration process, and as you can see here from this slide, 99% of the securities arbitrations that take place in the United States are administered through FINRA. Just to give you a way of understanding what this means, so we keep a I shouldn't say inventory, but maintain a staff of over 8,000 arbitrators, securities professionals, academics, individuals who have an interest or an understanding of the securities laws and so forth. And as you can imagine, a lot of disputes might take place between investors and brokers, or between two parties in this space. And instead of litigating it and going to court, this is a really effective means to settle the matter in a fashion that is similar to going to court without the labor-intensive, time-intensive, and cost that the courts bring. So if you have a claim against another party of over 100,000, you'll go through a discovery process. You will attend an in-person hearing where you or your legal representative will make a case, and a three-person independent panel, or at least one person has to be independent, will hear the case and then render a decision, which would be binding as far as the award. When there's a smaller claim, 50 to 100,000, you can have one arbitrator conduct an in-person hearing, kind of the similar process. And then when there's a smaller claim of less than 50,000, actually that can be administered in person. I'm sorry, virtually, not in person, through an arbitrator. And then alternatively, if the two parties feel that mediation and settlement is the best outcome either before or during the arbitration, then that's an option that both parties can mutually agree to, and then that will fast track and give an opportunity for people, parties, to come to an agreement without having a loser and a winner in the process. So I think that's a very important, function that we perform, because it really manages the means to which investors and brokers can settle disputes. So with that, I'll pause real quick and see if there are any other questions.
Yeah, I have something I'd like to just share with you, and I have a question. Back in the 90s, I worked for the government, didn't make a lot of money, and I joined Merrill Lynch actually through a Rotarian, and I had some invested in some REITs here in Washington that really performed well. I had that before I got with this party, and I went in to buy some more of this REIT, and he said, well, you got too much invested in the Washington area. I've got a real good REIT here that I've bought into. It's in the Midwest. And I said, okay. He convinced me that it would be better to spread my money in different parts of the country when it comes to REITs. Not knowing that it was a paper tiger. The REIT didn't own, what he sold me didn't own anything. They owned parts of other stuff. Yeah. And he was getting a kickback from Merrill Lynch for pushing this on me. The REIT that I wanted to buy never lost a dime. And the REIT that he sold me when the crash came went broke. I mean, I lost everything. And for me, it was a lot of money. And I have never trusted a broker since. I mean, this guy screwed me. And there were no, I didn't know of any rules. I just left Merrill Lynch and I do my own now. The second question is, this has popped up because of the internet, and you've got all these financial advisors. They're not selling anything, they're advising. But this seems to become a big business, and I'm getting inundated with people who are trying to, and I guess because I've explored a little bit on the internet, they're advisors they're like slick salesmen saying, you pay me X number of dollars, a couple of grand, and I'm going to give you the insides on what's going to be the best buys. Do you have any influence, or is there anybody watching what these people are doing?
Yeah, like I said, advisors are really operating on the principle of fiduciary, that they're performing their business for the interests of their clients. And Nick, I don't know at Edward Jones how much advisory work. I suspect that you guys probably do quite a bit of advisory work.
Yeah.
And so there's a distinction between selling and advising, which is obviously where we lie as far as the selling side of the brokerage community, right? So I'm just going to put this out there, and others might have opinions on this. But so in the wake of the Madoff and the Sanford fallouts and so forth, there was a moment where Congress, the SEC, considered employing FINRA to regulate advisors. But this is what was told to me for those who were part of the process, and I did work on some policy that attempted to make arguments for why we were an able entity to perform that work. But what it really came down to was the lobby for advisors is really strong, and they were able to convince those that would make the decision that the advisory community could regulate or protect, take care of itself with the current model with the SEC. That's just my impression. It's probably very limited in understanding the scope, but so to answer your question, Kent, that's kind of where we are, and we've been fortunate that there's been a relatively strong market for such a long period of time. So it's been a situation that's kind of played itself out naturally. When we have downturns in the market that's a little bit more sustained, we might start to hear and see some of the more complaints that you experience, in particular that you may have experienced. It's interesting that you bring up the REITs, because that's where I did a lot of work in the early part of my career, focusing on these types of products. They're highly complex, naturally, certainly a way to diversify your portfolio. But there sometimes REITs are sold and not necessarily bought, and investors do have to be aware of the intricacies, and in particular that it's usually a 7-year hold for some sort of liquidation event. You're looking for tax benefits. You're looking for obviously that income, and there's ways to diversify not only your portfolio but your portfolio of REITs and real estate assets for which they hold. So it's a really interesting area that has had its fair share of issues. It's a little bit on the downside right now. They had some roaring years in 10, 15 years ago. I did a lot of policy work when it came to broker-dealer regulation in the space, because getting compensation of 7 to 10%, that really induces the motivations to sell that type of product.
All right. Well, I think unless there's more questions, I think we'll end it there. We are about 10 minutes over time, but we can officially end the meeting, but that doesn't mean you can't ask questions. So if you want to stay and ask questions, please do. I just want to say thank you, Minh. Thank you so much for being with us this morning. We really appreciate your expertise and your presentation. So we hope to see you again. We always meet every week at 7:30. So if you're up early and you'd like to join us, we'd love to have you. And with that, I would say to our Rotarians, thank you so much for being here. We are meeting again virtually next week and throughout January. And we may actually meet virtually February also. We'll see how the numbers look. But go forth, be good in your community, be a good Rotarian, practice the 4-way test, and we'll see y'all next week.
Thanks, Minh.
Thank you.
Thank you. Very informative.
Thank you.
Bye.